So good afternoon and welcome to this Diversity, Equality and Inclusion case update. I'm Fiona Herrell. I'm a partner in the Employment and Immigration team here at Brodie's, and I'm delighted to be joined by two of my colleagues, Will Rawlinson and Louise Usher. And in the next 30 minutes, we're going to be looking at three significant cases which we think all HR professionals need to know about. They're set out on the slide, you'll have seen them in the invite, but it's Taylor and Jaguar Land Rover, the scope of the gender reassignment protected characteristic under the Equality Act. It's Forstater and CGD Europe and Others, looking at the protection of gender critical beliefs under Section 10 of the Equality Act. And it's Allay Limited against Gehlen, and that's looking at equality and diversity training in the context of the reasonable steps defence. Now, in reality, we probably could have spent the whole 30 minutes just talking about Taylor or just talking about Forstater. But as you know, if you regularly join our employment and immigration webinars, we like to keep them short and snappy and punchy. So what we're going to do is a quick canter through for each case, the facts, the underlying law, the decision that was reached, and then most importantly for you, what that decision means for your business and what you need to be thinking about doing as an HR professional in response to those decisions. So I'll pass over to Will and he'll get us started.
Thanks, Fiona. Yes, I'm going to cover the case of Taylor against Jaguar Land Rover. No doubt some of you will be familiar with this. Either you'll have read about it in the press or you'll have heard about it while you've been working with your colleagues. But just to give you a bit of the background here, the claimant was a long-term employee of Jaguar Land Rover. And in around March 2017, the claimant told a member of HR that they were transgender and thought herself to be on a spectrum, transitioning from the male to the female gender identity. And then later in 2017, the claimant advised their line manager that transgender was an umbrella term, and that in the claimant's case, the precise word would be gender fluid. The claimant then began to dress in women's clothing when attending the workplace. And she tried to maintain an open dialogue with the HR department throughout, and was also seeking support and ways to help improve visibility for those who are trans, non-binary and gender fluid in the workplace. And I think it's safe to say that the support that the claimant received was very uneven in that no one really took any ownership of the claimant's suggestions or her concerns, particularly when the claimant raised issues around hostilities they were experiencing in the workplace. For instance, the claimant advised that they had suffered insults, abusive jokes, and had also experienced difficulties in relation to their use of toilet facilities in the workplace. This all culminated in the claimant resigning and bringing claims in the employment tribunal of constructive unfair dismissal, direct discrimination, harassment and victimization. And those last three were all brought under the Equality Act and were pursued on the basis that the claimant had the protected characteristic of gender reassignment. And if we move on to the next slide, we can take a look at what that means. So the first question that the Employment Tribunal had to address here was whether or not gender fluid or non-binary individuals were covered by the protected characteristic of gender reassignment. The Employment Tribunal noted that this was a novel point of law and that there hadn't been any first instance case on this or any legally binding authority. And if we look at the relevant section of the Equality Act, which gives us the definition for gender reassignment, it's section 7.1. We put it there on the slide, but it's a person has the protected characteristic of gender reassignment if the person is proposing to undergo, is undergoing, or has undergone a process or part of a process for the purpose of reassigning the person's sex by changing physiological or other attributes of sex. And what the tribunal did was focus on the words, in the first instance, proposing to undergo, which they decided could be interpreted in a number of ways, including is actively considering, intends to, and has decided. They then focused on the second part, which is this process, and in particular, the words changing other attributes of sex. The ET had no problem, at least in finding that the wording did not mean anyone had to have, or indeed intend to have, any surgery in order to identify as a different gender from their birth sex. But the Employment Tribunal did have to consider what the intention of Parliament was here. And so they were referred to a number of sources by the claimant's representative and by Jaguar's representative during the case. That included a select committee report and explanatory notes from the Equality and Human Rights Commission. But ultimately, the tribunal found that the only really useful aid to the interpretation of this definition was the Solicitor General's comments in Hansard, which, for those who don't know, is just a transcript of parliamentary debates on the matter. And I'll quote some of those so that you can understand what Parliament's position was here. It concerns a personal move away from one's birth sex into a state of one's choice, a personal process which may be proposed but has never gone through. It may have happened, its nature may be a medical one, it may be choosing to dress in a different way and moving a gender identity away from birth sex. Gender reassignment is a personal process, so there is no question of having to do something medical, let alone surgical, to fit the definition. And someone who has a gender identity that is different from that expected from a person of their recorded natal sex is covered too. So all of this ultimately led the tribunal to conclude that it was clear that Parliament intended gender reassignment, that definition there on the slide, was a spectrum moving away from birth sex, and that a person could be at any point on that spectrum. As such, the claimant was protected under the protected characteristic of gender reassignment. If we move on to the next slide, we can see how this actually ended up in terms of how the case was decided. The claimant's claims were found to be well-founded in the main. There were a couple of examples of harassment which were either time-barred, but the tribunal's main focus was obviously on the ones that were still before it. And the claimant ended up being awarded £180,000 in compensation. Part of that was for aggravated damages, and I'll just quote what the tribunal said in relation to that. That was because of the egregious way the claimant was treated and because of the insensitive stance taken by the respondent in defending these proceedings. So it's not just the employer's acts, it was also the way that the actual tribunal was conducted. The tribunal did not find any favour in the respondent's argument that they were not responsible for the actions of their employees, which is the top bubble on that slide in orange. But the claimant was also awarded a further 20% uplift for the respondent's failure to follow the ACAS code. Jaguar Land Rover has since apologised to the claimant. They're not going to appeal the claim as far as we know, and they stated that instead they would use the outcome to inform their diversity and inclusion strategy, which did, given the size of Jaguar Land Rover, come in for some very heavy criticism from the tribunal, which, as Fiona's already alluded to, unfortunately we can't go into in a huge amount of detail today. But if we move to the next slide, we can just take what are the takeaways, I suppose, for employers. The first is to review all of your policies, all relevant policies, and ensure that they remain fit for purpose. Fiona will cover this in a bit more detail when we talk about one of the other cases, but it's important that you go away, have a look, and see if there's anything you need to update. Also, ensure that your staff are aware of the policies and that they're trained on them. And then some other practical tips that you might be able to implement relatively easily are to give your employees the option to specify their preferred pronouns. So it's not just he, she, her, it can be they, whatever someone else is comfortable with. And consider the practicability of introducing gender neutral toilets and, where possible, gender neutral uniforms. The reason we put that one in is, again, there was quite a lot of analysis in this case before the tribunal about what employers should do in terms of supporting people who are going through a process of gender reassignment and which facilities they feel comfortable using. And then also establish equality and diversity committees and an Allay scheme to make sure that there's visibility and so that people who are protected under the legislation know that they're supported in the workplace. So that's all from me on the Taylor case, and I'll now hand over to Louise, who's going to cover the Forstater case.
Thanks, Will. Good afternoon, everyone. So I'm going to talk about the recent Employment Appeals Tribunal decision in the case of Forstater against CGD Europe, which I suspect, like the Jaguar case, many of you will have already heard about, whether in the news or elsewhere. By way of background, Miss Forstater was a visiting fellow at a think tank, CGD Europe. She holds gender-critical beliefs, which include her belief that sex is immutable and it shouldn't be conflated with gender identity. Ms. Forstater was a fairly prolific tweeter, averaging, I think, between 5 and 10 tweets a day, and was regularly engaging in a series of social media debates on these topics where she was making her gender critical beliefs known. Some colleagues at CGD saw these tweets and considered them to be offensive, and so made complaints about them. When Ms. Forstater's consultancy contract was not renewed, she brought proceedings on the basis that she had been discriminated against because of her gender critical beliefs. It was then considered as a preliminary issue whether her gender critical beliefs were capable of protection as a philosophical belief under the Equality Act. So it's worth considering the framework for protection of a belief under the Equality Act. Religion and belief is a protected characteristic under Section 4 of the Equality Act, and belief is defined in Section 10 as any religious or philosophical belief, and that extends to and includes a lack of belief. In the case of Granger plc and others against Nicholson, the Employment Appeal Tribunal came to the view that there have to be some limitations on the protection afforded by Section 10, and in doing so formulated what is now known as the Granger criteria. And under Granger, in order to qualify for protection, there are 5 tests that require to be met. The first is that the belief must be genuinely held. The second is that it must be a belief and not a viewpoint or an opinion, which is based only on the present state of information available. Third, it must be a belief as to a weighty and substantial aspect of human life and behaviour. Fourth, it must attain a certain level of cogency, seriousness, cohesion, and importance. And lastly, the 5th criteria is that it must be worthy of respect in a democratic society, not be incompatible with human dignity, and not conflict with the fundamental rights of others. So in Forstater, the tribunal found that the first 4 Granger criterion were satisfied, but ultimately concluded that the claimant's beliefs were incompatible with human dignity and the fundamental rights of others, thus falling foul of the 5th Granger criterion. The tribunal held that even paying due regard to the qualified right of freedom of expression, people cannot expect their beliefs to be protected if their core belief involves violating others' dignity and or creating an intimidating or hostile environment for others. As a result of this, the claim was dismissed on the basis that there was no philosophical belief that was capable of protection. Ms. Forstater, however, appealed to the Employment Appeal Tribunal. In reversing the decision, the Employment Appeal Tribunal highlighted that Section 10 of the Equality Act 2010 requires to be interpreted in line with the human rights that are enshrined in the European Convention of Human Rights, most notably Article 9, which entitles everyone to freedom of expression, thought and conscience, and also to freedom of expression under Article 10 of the ECHR. There was some discussion in the case as to whether Article 17 of the ECHR, which prevents any person from relying on the terms of the European Convention of Human Rights as a means of destroying the rights of, or freedoms of others, would prevent Ms. Forstater's beliefs from qualifying for protection. However, the Employment Appeal Tribunal held that while Ms. Forstater's beliefs may have been considered, and this is a quote, offensive and abhorrent to some, the only beliefs which would fail to qualify for protection under Article 17 of the ECHR would be those that were akin to totalitarianism, Nazism, or espousing violence or hatred in the gravest forms. It follows that the beliefs which are offensive, shocking, or even disturbing to others can still be worthy of respect in a democratic society, and therefore can still qualify for protection under the 5th Granger criterion. So essentially, the decision was that a belief that there are only 2 biological sexes and that people cannot change their sex is a philosophical belief that is capable of protection. And the tribunal will now have to go on to consider whether CGD Europe's actions actually amounted to discrimination, because it is worth noting that despite the significant commentary on this case. It is only at a preliminary stage. So what does this mean for employers? Well, as I've said, as a result of this decision, employees with gender critical views are going to be entitled to protection from discrimination and harassment. However, it's important to note that the Employment Appeal Tribunal, in a way that's very unusual, made it very clear that it was not expressing any view on the merits of either side of the transgender debate. It's expressly stated in the judgment that nothing in this decision entitles anyone to misgender trans persons with impunity. And equally, it does not mean that trans persons or individuals that are non-binary do not have the protections under the Equality Act that Will's already described. And finally, it doesn't mean that employers and service providers are not expected to provide a safe environment for trans persons. So with both sides of the debate likely to be protected under the Equality Act, the focus for employers will have to be on manifestation of those beliefs and ensuring that no one feels harassed or bullied either because of who they are or because of the beliefs that they hold, even if those beliefs are considered to be unpalatable or potentially offensive by others. And I think that takes us quite neatly onto the compelling arguments for having an up-to-date equal opportunities policy in place and having regular and meaningful training on diversity issues, which is what Fiona is going to come on to speak about.
Great, thank you, Will and Louise. So the third case that we're looking at today is Allay UK Limited against Gehlen. So the claimant here worked for the respondent for a relatively short period of time, as I've set out on the slide. He described himself as being of Indian origin. After he was dismissed for his performance, he raised with his former employer the fact that during his employment, he considered he'd been subjected to racial harassment by a colleague, Mr. Pearson, during his employment. And specifically, he alleged that these harassing comments had been made to him on a regular basis by Mr. Pearson and included things like the fact that the claimant should go and work in a corner shop, references to the fact that him driving a Mercedes car was just like all Indians, and then Mr. Pearson also asking the claimant why he was even in the UK. The respondent undertook an investigation. It found that Mr. Pearson had made racist comments. Mr. Pearson described during the investigation those comments as being racial banter, and I'm sure at that point the hearts of the HR professionals involved must have sunk, because we all know that when somebody says, well, yes, I said it, but it was banter, then we think, oh, for goodness sake. Here we go. So that was how he sort of described it or categorized it. And the respondent arranged for him to undergo some further equality and diversity training. He had already attended some training, and the respondent did have policies and procedures in place, and I've set those out on the slide. So there was an equal opportunity policy and an anti-bullying and harassment procedure, and those both sat within a staff handbook. And in addition, there had been equality and diversity training in January 2015, so before the claimant had joined in October 2016, and then there had been bullying and harassment training the following month in February 2015. And that training included a slide on what could be considered to amount to harassment, and it specifically referred to offensive jokes, suggestive or degrading comments. So those who had attended that training were on notice as to what could amount to harassment. So perhaps unsurprisingly, the respondent in this case sought to rely on the reasonable steps defence. And so just reminding ourselves of what that is. Under the Equality Act, an employer will be liable for the acts of its employees committed in the course of employment, discriminatory acts, I should make clear, committed in the course of their employment, unless the employer can say, we took all reasonable steps to prevent that from happening, and therefore we shouldn't be on the hook for the acts that our employee has committed towards another colleague. So that's really what the respondent was trying to hang its hat on here. I think it realised it wasn't going to be able to say that there hadn't been harassment, but that it has a reasonable steps defence. That is a really high bar to meet. And I think many of you who've been involved in claims where there are harassment discriminations made in particular will know that it's not enough to have a policy. Even if it is a beautiful policy, it's not enough to have a policy. When thinking about reasonable steps defence, a tribunal will consider what, if any, steps have been taken by the employer, and were there any other reasonable steps that should have been taken. And we now know it's well established in the case law that it's things like up-to-date, comprehensive, effective policies, regular training, and making sure that people in your workforce are actually living and breathing those policies and guidelines and codes of conduct. And not just, yes, I've gone to the session, I've listened to it for an hour and then I've disappeared off again, but I wouldn't know what to do if I saw harassment or experienced harassment. In determining whether steps were reasonable, a tribunal will think about the likelihood of the steps being effective in preventing discrimination and also the cost and the practicality of implementing it. But if a tribunal thinks that there is a further step that an employer has not taken and that it would have been reasonable for them to take that step, then the defence will fail. If we move on to the next slide then, so I've just summarised where the Employment Tribunal and the Employment Appeal Tribunal got to on this. So at first instance, at the Employment Tribunal stage, it decided that the respondent had not taken all reasonable steps to prevent the harassment. It made a finding that the training was clearly stale, that a reasonable step would have been to refresh the training, and that the need to refresh the training was evident by the fact that after having attended that training, Mr. Pearson still went ahead and made these comments. And a colleague and two managers who were aware of the comments being made had failed to properly react when becoming aware of those comments. And I think the training had specifically called out, if you become aware of this type of conduct happening within the workplace, this is what you should do. And people had been aware, or the tribunal made findings that people had been aware, and they hadn't then followed the procedure. And that was what led the tribunal to make this finding that the training was clearly stale. The respondent appealed to the Employment Appeal Tribunal, and the Employment Appeal Tribunal looked at it all again and was satisfied that the Employment Tribunal had sufficient evidence to conclude that whatever training there had been, it was no longer effective. So either it hadn't landed well at the time, or because of the passage of time, people had forgotten, but either way, it was not stopping the harassment from happening in this workplace, and so it was no longer effective. They also found that there was nothing in the case which suggested that further training of a good standard would not have had a good chance of being effective. So I think the employer was basically trying to say Mr. Pearson was a bit of a rogue, and even if we had given him further training, it might not have prevented the harassment from happening. And the Employment Appeal Tribunal picked up on that and said, well, but you arranged for him to go on further training after the investigation. So you must have thought that there was at least a possibility that that further training would have the desired effect. And so actually, we don't have any issue at all with the Employment Tribunal's decision that there weren't all reasonable steps taken, that it would have been reasonable for you to have refresher training. And the EAT also issued this reminder that an employer seeking to rely on the reasonable steps defence really does have to cross a really high threshold in order to be able to achieve that. So in terms of the action required, it's sort of echoing what you've heard already. It's consistent themes rather than adding your to-do list. It is looking at your relevant policies and your training materials on a regular basis. I think the Allay decision in particular makes clear that the tribunal will scrutinise. It's not enough to say we have a policy and we have training. They will actually be looking at what is in your policy, what is in your training, who delivers your training, how regularly is that delivered, who attended it, did people understand it, or did they just pitch up and listen to what had to be said, but they didn't really understand what was being discussed. And I thought there was a really sort of helpful comment from the tribunal where it said, it's not sufficient merely to ask whether there has been training. Consideration has to be given to the nature of the training and the extent to which it's likely to be effective. If training involved no more than gathering employees together and saying, here is your harassment training, don't harass people, now everyone back to work, clearly that's unlikely to be effective or to last. And I think that's really the point that the EAT was trying to make in this case. So actions required there. And I think in light of the decisions in Taylor and in Forstater, having a look at your policies now to say, what do we say about trans rights? What do we say about gender critical beliefs? Are we satisfied that our policies are up to date in light of these current developments in the case law, or do we need to make any tweaks in relation to them? Do we think that we need to have any additional policies? Do we have a transition at work policy to support trans colleagues who are transitioning? Is that something that we think that we should have? Might we have, if we have a colleague network, should we ask them if it would be helpful to have that type of policy in place? I think that would all be sort of very helpful steps for an employer to be taking at that stage. The final slide that I just wanted then to sort of finish up on is really just our reflections on where this all takes us, because it's not just about having policies and procedures in place. We have to recognise that if, for example, Taylor and Forstater had been colleagues within the same workplace, there quite possibly could have been a very sensitive situation there that had to be managed. We will likely have scenarios where one employee's beliefs conflict with or are opposed to the beliefs or rights of another employee, and both employees are protected under the Equality Act. Now, we'll have that already because we had that already, before these decisions, in terms of people who have different religious beliefs, in terms of people whose religious belief perhaps conflicts with other beliefs, maybe in relation to gay marriage. There might be conflicts there. So it's not a new concept, but I think this just brings it back into focus again in terms of balancing, for example, trans rights with gender critical beliefs. It really does just drive home and underline the importance of us having a genuinely diverse and inclusive workforce where colleagues are respectful of all rights and beliefs, irrespective of their own. And it just reinforces the need, I think, for effective policies, procedures and training, and probably a little bit of education as well, so that colleagues feel comfortable and confident in dealing with their colleagues and speaking to each other, and aren't going to be afraid of saying the wrong thing or accidentally offending somebody, but actually are doing it from a place where they understand more, and also there's been sort of open dialogue around how we should all be acting alongside each other. Clearly, if we get a complaint or a grievance that is raised alleging that the expression of a right or a belief amounts to harassment or discrimination, and we've got this opposing rights or beliefs as clash, if you want to call it that, obviously that's going to require a delicate balancing exercise and very sensitive management. And of course, at that point, it would want to be, you'd want to be ensuring that the people who are involved in trying to handle that and resolve it are people who have been appropriately trained. There's not going to be an easy answer to it. It's going to be a very delicate balancing exercise, as I've said. And so that's going to come down to sort of people who are very experienced and knowledgeable in this area. Conscious of the time, and that there aren't any questions that have come through so far. So I presume that means that everybody's thinking, right, what am I going to go and put on my to-do list? Possibly not a sort of this week or this month to-do list, but your longer term to-do list for sure. If anything does sort of crop up or occur to you after the session, delighted for you to get in touch, and we can have a conversation about that separately. But otherwise, we'll just say thank you very much for joining, and wish you a very good afternoon.